but I can't tell you who's going to do what, and that's part of it. I have heard of one person who was told they have a court date in Forsyth this Friday for 2 evictions. I'm surprised by that. They did call after I voiced my surprise. They called and said, and the clerks told them yes, that they were scheduled. They didn't need to be there. So they're going. We'll find out what happens. But I'm not expecting that to go anywhere. I'm expecting them to get there and the magistrate to go, no, I can't hear this. We're going to stall this off. And I think that was a result of just calendaring, because anything that was already on the books, they're trying to get on the calendar now. And so I think that's what happened with him, is somebody said, hey, look, this was already here to be heard because it was an older case. And they just put it back on the books, and nobody's thought, oh, wait, we're not able to hear this right now.
Okay. Okay. Like I said, I just wanted everybody in the group to know what our experience was, so that if you were thinking about going, if you didn't know whether the moratorium was still going on, apparently it still is. Because we were told that we could go ahead and file it, but if we did, and the judge dismissed it, we would lose the money that we had put in the filing, for the complaint, summons and complaint.
Maybe.
Hey folks, nice to be here. My name is Mike. Just to add this in case it's useful to anybody, we put in our notice for eviction court filing that just prior to the COVID situation, and the court date keeps getting bumped, but it does remain on the calendar at least. So June 25th, if it doesn't get extended again, which we think it probably will be, we'll have our day in court.
Okay.
Thank you.
Thank you. Well,
Yeah,
I went down there yesterday, so that may make a difference. But we had been told that that wasn't going on anymore, so that's why we went down there to try to file it. But apparently, even though they can't say you can't do it, they encouraged us to rethink it. And we are definitely going to wait until June 22nd to file it.
Thank you all, and we're going to mute and then let the meeting carry on at this point, since it's 14 after on my computer. So I'm going to mute out and let the meeting continue.
Okay, can you hear me?
Yep, go on. Go, Andrea.
Okay. Hey, everybody. Welcome to our first Zoom meeting. Hope everybody's doing well. Or it's our second virtual meeting, but our first Zoom meeting. And if you are a participant only, please make sure that your phone is muted. And to mute and unmute on your phone, you press number 6. Last Friday, I just want to let everybody know, last Friday, on behalf of the GLA, we sent a letter to the governor asking that he respect our needs and requirements as landlords when creating the new executive orders. We gave several examples and recommendations, and made recommendations for future orders, and also requested that our current statutes be reviewed and rewritten since they are no longer pertinent in our new world. We know that several of you are hurting because you have not been able to conduct lockouts on already evicted tenants, as we're going to talk about. And one recommendation that was made by a magistrate is to ask if the tenant has the back rent and the current rent now to pay up in full. If they do and you want them to stay, this is a way to retrieve your payments and to clear the eviction from the lockout list, which the sheriff is supposed to start again on June 22nd. To continue with these types of discussions, we encourage you to join us for the coffee chat next Tuesday, June 16th from 4:15 to 5 o'clock. This will also be a virtual and call-in meeting as well. And Jen will email us the meeting information later this week. Right, Jen?
Yep.
Okay. Next month, we just want to let everybody know there will not be a meeting, as this is usually our vacation month for everybody. And everybody knows that right now we all need a vacation from this crazy life. And I hope everybody has a great vacation wherever you go next month. Now we're going to get into our meeting. The topic is security deposit reconciliation with our very own board member and local attorney, Preston Nelson. And we want to let Preston get through his presentation this evening. So if you'll please, since we're all at home, we've got access to our notebooks. If you'll write down the questions and hold them to the end for Q&A, unless it's a really, really tough question and you need to ask him at that moment. In that case, go ahead and raise your hand, and there's a little thing on your screen that you can do a raise hand. And Jen's going to tell us how to do that. And that way she will see you with your raised hand on your screen. Thank you, Preston, for giving us your time, and we're going to let you take it away.
Actually, Preston, let me just explain real quickly how to do the raise your hand. Obviously, you can do it this way and I'll still see you. But you can go down into the bottom part of your screen where it says participants and click on that and open it. If you look to the right, there'll be 3 dots. And you'll click on the 3 dots and you'll see raise hand. And then it will raise a hand. It will show me on your photo. For any of you all that are on your landline or cell phones, the only way you're going to be able to do it is to interrupt. And it's actually *6 to mute and *6 to unmute. It's a toggle. So just wanted to let you guys know that. And I am now going to bring up, Preston, your presentation and mute myself.
Perfect. Thank you, Jennifer. Yeah, so this is residential security deposits. I really don't talk too much about reconciliation because that's more math and accounting. I got this title, Thoughts from a Friend, because while I might be an attorney, I'm not your attorney, and I'm not giving anybody legal advice here. So if you do something based on something that's said tonight, that's at your own risk. Don't call me, don't sue me. I'm going to deny it ever happened. But that said, you know, I am here to give you my thoughts, and it's kind of color-coded just like this slide. So the blue stuff is the thoughts I think are helpful. The red stuff that should jump out as the important bits of law that I think you should get. As Jennifer said, I kind of got it in a lineup, so it made sense to me that we're going to build on what we're getting to. So if you have a question, there's a very good chance the next slide is going to answer or talk about that topic. So just kind of hang out. This is really super important, and we'll get everything at the end. Jennifer, you want to move us ahead? All right. So you have the deposit, and you got to get rid of it, and that's what this is talking about. So most of the standard leases, I forgot to say this. So I'm trying not to make assumptions on what lease you have. Most people are going to have the standard realtor lease because of property managers and because that's what people want to have. Even the standard leases are not all the same. They change them constantly. At least on a yearly basis, they're trying to update those. So those do change. So if I'm telling you something, it's because it's important to know, not necessarily because it's covered in lease and it's come from there. This is all statute driven. If it's related to a lease or a standard, I'll point that out, and that's coming up one of the later slides. So yeah, you still have to get rid of. Oops. Backwards. You still have to get rid of the deposit, and so when we're doing closings, that's usually when people are like, well, how do I get rid of this and what do I do with it? And there's a statute right on point, and I've got it listed out here by the statute number. And a lot of times the property manager, if you have a property manager, will do that transfer for you. If we're not doing it that way, we'll have it either paid into closing, and we'll have it as a line item paid back out. So it's a record of that transaction for you on what's happening. It should never really come from your own funds. And it should also never get paid into your purchase price because of the fiduciary rules that come into effect. But as long as you're letting everybody know what's going on, particularly when you are buying and selling, most of this gets handled for you. If you want to go to the next slide. All right. Because we're talking about deposits, we're going to talk about the pet fees. And while the statute says pet deposit, if you call it a deposit, it is now a security deposit and falls under security deposit rules. I think that's silly because the statute's on point, but that's exactly what's going to happen. And to some degree, I think that's the right answer, because when in the law, we say things and the words have a special meaning, and that is the term of art. And so when you're talking about deposits, the only term of art in this relationship for these residential leases is a security deposit. So if you want to charge a pet fee, it needs to be a fee. If you call it a pet deposit, I'm going to tell you almost all the time that you're going to have to return that, unless there's damage from the pet. Now, of course, there's almost always damage from the pet, but that's a different answer because sometimes there's not. So again, it's always needs to be a fee, and that'll be a theme throughout. Is the language that you use when you're setting these leases up and when you're dealing with folks is very important. And you want to be careful what you call a deposit versus something else. Next slide, please. All right, so 4250, this is the main setup for you. So you got to have a trust deposit, and you got to spell out where it's going to be and how it's going to be. And this is the most important from my perspective, is getting this set up right. It's easiest to do it in the lease, to go ahead and tell them that it's in this trust account with this bank, this institution, and the things of that nature. Because if you don't tell them, you have already forfeited the deposit. So we want to make sure that you do that. It does have to be an institution in the state, and because that's, and in the law, we do that a lot. We want it to be things that we can control, and we can control things only in this state or having some tie to this state. So that's why we're looking for in-state banks or banks that are licensed to do business here. I've never seen anyone do this, but you can furnish a bond instead of having that set up, and that's so that you can have it protected differently. I have toyed with the idea personally of one day having a management company and having hundreds of rentals and taking the deposits and putting them in a stock account and investing that. And this would be part of the way that you would do this. And you see that, or a trust institution. So it doesn't have to be a bank account per se, but it needs to be a separate account. And this says trust account. We'll talk about trust accounts in a second. But so in theory, you could take all the rent money and invest it and keep the premium. Now I would suggest that if you're going to do that, you probably also need to furnish the bond. And I haven't looked into doing that to see if it makes sense, because I don't have enough float money for me, but potentially that's an additional revenue source for property management, if that's something that you want to think about. And again, you know, if you don't tell these people within 30 days or it's not in your lease, you've got a problem. Next slide, please, Jim. All right, so this is the question that gets asked based on that last one, because it says trust account. And if you go to your bank and you say, I need a trust account, they're going to look at you funny. And part of that is because a trust is a legal entity more often than not. There's a few things that you can do that are not real entities, but they set them up. Totem trust is one that I like. I like the way it sounds, which is a trust that exists, but nobody knows it exists. But we kind of think it does, so we're going to act like it does, which is different from a constructive trust, which is the trust was meant to exist, but nobody did anything, but we got to protect the people. And you'll see a totem trust kind of as a pay on death account, is a close approximation to how that works. And in some situations is truly a totem trust. So if you're going to your bank and you're saying you need a trust account, they're thinking entity, which is totally different. You can see here, these are the actual definitions. And a trust is a right of property, real or personal, held by one party for the benefit of another. And so that's what a trust is I am taking something and I am holding it for someone else in trust. They are trusting me to do that. And that is the essence of what a trust is. And so the trust account is an account essentially to hold those funds in this case. And I tried to get you a definition of trust account and there isn't one, because again, this is it's an account being held in trust, but trust deposit was a definition that's already been defined in Black's Law Dictionary, which is the main dictionary everybody uses. And it literally says that it's where we put this money in these accounts to keep it separate and not commingled. So if you're taking money and putting in your operating account, you've commingled it. We can't ever tell what happened to those dollars, because money is fungible, it disappears, and as soon as it goes into your account, the trust situation gets obscured. And so that's a violation of the security deposit trust account rules and the fiduciary rules that come in from being the trustee of this limited trust that we're creating. So it's very important that you keep all of these funds separate. And if you are not doing a ledger, you probably should be. And this is the reconciliation. So the way I've done it in the past with QuickBooks, is because most people do QuickBooks, is a sub account or a subclass, depending on how you look at them. And so you've got your main trust account, and underneath that trust account is a sub account for each tenant, each trustor, I guess in this case, because you're the grantor creating it, but they're the person who's giving you the funds to keep in trust. And so that's their line item inside your main account. So it's not just this big pool of money that you go, okay, well, I put in some money to begin with, and now this person's leaving, I'm gonna pull some money out. No, you go in and you pull their money out to the best that you can with money sitting in an account. You're gonna pull out only their $500 or whatever the deposit is, not a random $500. And so you want to keep it in a check in some fashion that way. That's the reconciliation that's going to happen, where you're going to match those funds up. That's going to depend on your accounting software or how you manage your books. If you do that in an actual ledger, that's going to be on paper. It's the same idea. Each big account is going to have sub accounts, but the reason you're doing that is because your job is to protect those funds. As to those funds, it's your job to make sure they exist. And there's a fiduciary relationship that's happening there. If you give me the next slide, Jennifer. Landlord's obligations. So this is talking about, again, you've got a responsibility to make sure those funds get where they're going, because they're not your funds. They belong to this other person, at least until they don't. And so when the lease is ending, at least the way we're set up currently, that's usually the trigger point for these funds to get dispersed in some fashion. And you have 30 days to tell them what's happening with these funds. And so if you know the whole thing's going to get sent over to you, tell them that up front and say, look, here's the line item of what's going on, what we're spending, what the damages were you didn't pay, whatever you're going to charge on that, and get it to them within 30 days. If you don't know what's going to happen within 30 days, you need to tell them in 30 days, I don't know, but here's what I think. And then within 60 days, you need to give them a final answer, because that's the limit. If you don't get them an answer within 60 days, anything that you haven't told them is now theirs and has to be returned to them. And so that's your time limit. And if you fail to do that, then I think that's one of the ones that potentially voids, and they're entitled to the full return of everything. And the notes here, the standard lease for the realtor lease used to say that after 6 months, if you couldn't get them to find them and get them to take the money, you were no longer liable to them for the money. And that's kind of a way of saying the money belongs to you. That's not the best way to say that, but that's in a sense what was happening. It's my understanding that with the 2019 lease, they changed that and took that language out. So the realtor leases don't specifically say what happens with those funds anymore. So that's kind of a change. It's not a huge issue for most people, but that's something to be aware of, because again, this is not your money, and at some point you have to get rid of it. And then obviously the wear and tear, you can't withhold that, and we'll talk about that later, so we'll skip that for now. Next slide, please. All right, a sheet. So this is what happens to money that is not yours, that you cannot otherwise get rid of. And so we have rules in place that say at a certain point in time, if you've got money that belongs to somebody else, you have to do something with it. And what that is a sheet. We essentially give it to the state to hold for a little while longer. And if at a certain point in time, nobody comes asking for it, the state's going to keep it. And so this is a good way, if your lease does not say what happens to those funds after a certain period of time, what happens, because at a certain point in time, you want to retire, quit, sell the building, or just get out. And you have to do something with those funds that you're holding in trust with you. You can't keep them yourself unless the lease is saying that you can, or they're otherwise accruing to you. You've got to give them back to the person who gave them to you. And barring that, you're going to escheat it. And at a certain point in time, they're deemed to have abandoned it. And this is how that works. Essentially, if they don't come ask for it, they're deemed to have abandoned it. If you'll give us the next slide. And it is presumed abandoned if they don't show up with a certain period of time. I've highlighted two different, because there's a whole list of things that you can go through for different items that are coming in. The two most relevant here are the demand deposits, savings deposits. That's your saving account. So if you're looking at it from that perspective, it's 5 years. Very likely that's probably not the right answer for us, because that's not how, to the trustee, to you as the trustee, that's what's going to happen with the bank if that money is still sitting there. But between you and the tenant, you're more likely looking at 16, which is the general catch-all exception. After 5 years, you're going to need to look to get rid of this money if you still have it. Next slide, please. You don't have to necessarily hold on to the money for 5 years and just sit there and account with it and everything else, and then get rid of it all and having wasted your time. But the key takeaway here is it needs to be in writing what's going to happen. When I do contracts for my engagement contracts for myself, I've learned that I'm going to put in a dormancy clause of some description. So I actually have essentially two. One is every year I have to deal with this, I'm going to deduct a fee for dealing with it. And then two, at a certain point in time, certain funds will just become mine because it's easier to deal with that way for small amounts. That's on a professional engagement. That's a little bit different than what this is, but essentially it's the same thing. If you want to have in your lease what happens to those funds and whether or not you can keep them and they essentially become your funds, if you don't have that in the lease agreement or some other agreement that's attached to this relationship, you have to get rid of those. You cannot keep them. And next slide, please. Permitted use of the deposits, and this is all, and I've started with section or paragraph B. A is next, and this is because it's going to build again. You can only hold under current law so much of deposit versus the rent and the time frame, and that's what we're looking at here. And the big one for most people who are renting under regular leases, year-long leases, it's going to be 2 months. But a lot of people have month-to-month tenants. And if you actually read it, the month-to-month can only have 1.5 months rent, which is interesting because the way the standard realtor lease, and it's a realtor bar lease of some description, mostly realtor lease, is set up is that all of our year-long leases convert to a month-to-month tenancy and does not change the security deposit that's being held. Personally, I have never seen anyone raise this as an issue for a tenant. I've never raised this as an issue for a tenant because it has never been something that's occurred to me as really being a big deal, because we started out with a year-long lease that would have allowed for it originally. And whether or not that's the right answer, I don't know, and I'm definitely not going to say. I'm probably never going to raise it unless I'm paid a lot of money to deal with it, and tenants almost never pay. So that's probably not going to be something that's going to get litigated. But I got to tell you, that's what it says right this second. And so that might be a consideration for you, for people who are risk averse, that you want to consider. Do you want your year-long leases to convert to month at some point. And if you do you want to have a reset on the deposit that's happening there? It's something to consider. And so you got to have that conversation with whoever's helping you put this together. And that's something for you to think about. Next slide, please. All right, so security deposits can only be used for these essentially 8 things. Nothing else. If you are using a security deposit for anything other than non-payment of rent or services that are rent related, like water or sewer that you're providing, damages to the premises, non-fulfillment of the rental period, unpaid bills that become a lien against the property. And in Greensboro, the water bills did become a lien. Not currently, but so there's some people who might still have some old tenants with old accounts that might still could become a lien. That could be an issue now. Cost of re-renting the premises after breach by the tenant, or removal and storage of the tenant's property, court costs. And number 8 is kind of a catch-all for the late fees and eviction fees and a few other things, and we'll share those on the next slide in a minute. Go back. Yeah. So number 5, the cost of re-renting the premises after breach by the tenant. This and the non-payment of rent is where I would look if we're thinking about having fees being charged to tenants that are not quite these things. Those are where they're going to fit in. There's going to be some cost that's related to that. I know some people are charging cleaning fees, and that's going to be maybe related to damage because you've damaged it. You're cleaning it. There's something that's damaged there, or it's a re-renting cost. I have looked today, just kind of as a refresh, and there's really only one case that I can see that specifically discusses this statute. So it's not really clear what the limitations are. It's got to fit into these things. And if it doesn't fit into these things, you cannot charge it against the deposit. If it is one of these things or fits into one of these things and probably says that in your lease, then you can probably get away with charging it against the deposit. If you'll go to the next slide, Jennifer. This is the number 8. This is the kind of a catch-all. So your out-of-pocket expenses. So that's your late fee, your complaint, your court filing, second trial. Those are again your standard realtor leases, and you can only charge some of them some of the time, so not all the time. So that's why there's kind of a lump in there. Filing fees charged by the court. So that's your court filing fees and your service costs, which is some of that. Reasonable attorney's fees. Everybody thinks they're going to get attorney's fees. The contracts say attorney's fees. That's 15% of what you win, or maybe your rent, whichever is lower, if you're lucky. You almost never, ever, as a landlord, win attorney's fees. You almost never, ever, as a tenant, win attorney's fees. I have won attorney's fees one time. I got $150 in attorney's fees on a $1,500 fee case. So they got 10% of what they were spending for doing that. That's the best that I've ever seen anybody do in one of these low-level landlord-tenant cases. It was with Magistrate Mevin, which was a real surprise for everybody when he was on the bench because he never gave it. I just had one of those cases where everything just lined up perfect, and he gave it to us. But that's the big takeaway. Is you've got to calculate anytime you're doing an eviction or anytime you're dealing with a tenant, you want to get out for the lowest cost to you as possible because you're never going to get that money back. What you have in the security deposit, that's it. So if there's people out there who think that a 1-month deposit is okay, personally, I think a 2-month deposit is the bare minimum. And so I was shocked when I learned that people called a 2-month deposit a double deposit. I was like, no. That's the deposit. That's what you want because that's all the money that you're ever going to get. And you guys probably know this too. You're not going to collect from a tenant. They're almost never going to end up with assets. And if they do, there are so many exceptions and exemptions, you're never going to collect. The out-of-pocket costs, the out-of-pocket expenses listed in this section can be included to cure default. So you can make them pay you these things to get caught up. And I charged to my tenants, if we file these things and we've gone to court, but we reached the deal as part of getting out of court, I say, you got to pay me these things because I would win them in court. So that's helpful for you if you are working out a deal. Next slide, please. Remedies. So there's a statute that says this is exactly what happens in relation to noncompliance with the deposit. And I highlight the big here, which is a full void of the deposit. Now, when we get to the next slide, we'll actually walk through the whole thing. But this applies to everybody, and this is all residential, everybody except single rooms being rented. So if you're renting just a room, you can get away from these remedies. So that's something to think about. Maybe a room and a shared common space could be okay. I'm not certain. Now, that said, Chapter 75, the unfair and deceptive trade practices, we fit squarely into that. So even though these remedies don't apply, and that's the full forfeiture, that's really what you're worried about, you can still get hit with treble damages and attorney's fees and some other things depending on your unique situation. So don't think that just because you got a single room, you can get away with being a bad landlord, but it does give you a little bit of grace if you screw something up. If you'll go to the next slide. All right, so Neal v. Custer Real Estate Services. This is really the only case that directly talks about our permitted uses and the remedies section. And the background on this was the management company, well, they were trying to do a class action against the management company, and the management company was charging a $40 administrative fee and doing some other things that were listed on the ledgers as being security deposit forfeits for things like washer and dryer and some other, and there's a number of issues, but the main thing was they were adding cost on and presumably were taking them against the security deposit. And they were trying to say, the tenants were trying to say that because they had done that, that the full deposit was forfeited and had to be returned to them, plus attorney's fees and treble damages, yada, yada. And so the court walked through the remedies that were available in different sections. And so they really said there's 4 different items. There's the appropriate refund remedy, the full refund remedy, the damages remedy, and the attorney's fee remedy. And so walking through those, it's if you screwed up on telling them about where the security deposit's held, if you screwed up on getting them an accounting at the end of the term, that's the full refund remedy. You are going to give them all of that deposit back. And if that happens, then you're also probably going to give them attorney's fees and potentially treble damages. So that's what you're going to look at. Anything else is going to fall in either a damages remedy, because and this is where you're going to think about abatement cases, which I don't have slides for, but we can discuss later. Or an appropriate refund remedy, which is where you guys are having a negotiation about should you have charged as much as you did for them destroying that carpet. Because at that point in time, it's not, can you do it? Because the answer is yes. It's a question of how much can you do and charge for that item. What's really important from this was a Court of Appeals case, so this didn't go to the Supreme Court. So this could be overruled at some point if it went back up. But the court never really answered the question about what could they do. All they did was say, this is not an immediate void, so go back and figure it out. And also, you can't do a class action because everybody's going to be different, because almost all of these are going to end up being an appropriate refund remedy. So they're going to do an accounting. So that's helpful because that means you are not going to look at a class action very likely. We have already tried that, and the courts have said, no, the class action is not going to work. We haven't said that what you can and can't do per se. We've outlined where we think you need to look and how you should think about it. But we're not saying, they haven't said you can or can't do this, but they have said, bring us one at a time. And that changes the calculus on attorneys coming in, plaintiffs' attorneys trying to take down larger landlords, because that's the only way they're going to make money on doing these landlord-tenant cases. Is a lot of people, and realistically, that's not going to happen based off this case. The important takeaway for us as landlords, though, beyond that, was the court came in and said, and this is the highlighted in blue, we can find nothing in the act that will prevent a landlord from fining tenants for violation of health, safety, or other rules and regulations such as plaintiffs agreed to in their lease addenda. And then they were agreeing in some of these cases to paying additional fees. And this is where it's important that it needs to be stated, you can charge them. The court has said that you're barred from taking them from the deposits, but you could charge them. And so this gets back into how are you defining these things? What are they? Do they become a rent? Are they a damage component that fits under a damage? Or are they somehow related to a breach of the tenant? Not doing them is a breach that makes them the damage that you can collect from the deposit. And so that's the question there. I'm going to say this now because I think I was going to get to it. You want to think about how you're doing these things at a certain point in time. If you can't charge it against the deposit, you're going to want to try and collect it. And so again, your best bet is to have it clearly specified in the lease that these things become a rent or a damage that you can collect in the lease. If you don't, then the next step may be to consider that I, as the trustee of these funds, have released them to you, but as part of releasing them to you, I am going to take fees that are owed out of them after they've been released. Again, that probably should be in your agreement for how you're setting that up. Again, when you're defining how you're going to handle the return of those funds that belong to the tenant. Notice what I'm saying there. These are the tenant's funds that you are returning to them, but as part of returning to them, you're going to pay their bills for them. And there's a huge distinction there, because I'm trying to say at a certain point in time, again, if properly structured in your lease, potentially you could get away with that. I'm not going to say that you really can, because again, the language is critical on how you would do that. And I've seen a lot of leases that I'm like, no, never going to work. Or two, you could kind of just charge it and see what happens, because, and I'm not advocating that, but I'm saying that this is essentially what most people are probably doing in reality, is they're charging them. Essentially, here, you're going to get your deposit back, but then I'm going to charge you these funds, and since I've got them, I'm just going to keep them. That's going to push you into an appropriate refund remedy situation. So maybe it works out for you, again, because you're dealing with a person-on-person basis, and a lot of times the numbers make sense. So I can't say, but that's what I think most people are doing. Is yeah, that's the real answer. Next slide, Jen. Some more definitions for you. Rent, that's the consideration paid for the use or occupation of property. And I like that. And a little anecdote, interest is actually a form of rent. So it's not just related to the property of real estate. It's anytime you are giving someone the use of something else, they're paying you a rent. And that's what we think of it from the legal perspective. Ordinary, and this is because everybody's asking about the ordinary wear and tear. Nobody knows what that is. But based off of the legal definitions of ordinary, it's the things that are customary and reasonable and characteristic of the normal or average. And this says individual because this is the way it's geared. But for us, it's the things that 99.9% of people are going to go, yeah, that needs to be ignored, or that's beyond the scope of what we would expect to happen. And to correlate with that on repairs, because it's not an ordinary wear and tear definition, but there is an ordinary repair, and that's the things that are needed to make good the natural and unavoidable decay. So if it's something that could have been avoided, it is probably not ordinary wear and tear. So if you put in brand new carpet and they walk on it and with shoes and there's a sandy property and the sand just wears it out, not a whole lot of people are going to say that that was fully avoidable. I mean, now, yes, there are things we could do, but let's be honest, we all wear shoes in the house. But if you come in and there's grape juice and wine stains all over it, that's probably going to be a much more likely to be an avoidable event in theory, because you're not expecting people are going to come in and paint your carpet, essentially. So in that case, if you're telling them they got to replace the whole carpet, that's probably much more likely to fall outside of ordinary wear and tear than use over time. And I think that's the important thing, because the next question that most people are probably going to ask, and I've heard asked in this group before, is it's brand new carpet, and I normally replace the carpet every 5 years, and they wore it out after 2 years. Can I charge them the whole 5? I don't know. Nobody knows. It's what makes sense in the circumstance is what you're really looking for, and use these as, are you the crazy guy who's going to charge for it where nobody else would? If that's the case, stop. But if everybody else is doing it and nobody's complaining about it, it's probably okay. If it's you come in and you look at this and go, if this was my house and I destroyed this carpet this way, would I be mad at my kids and would I be upset, and or would it be like, man, stuff happens? I think that's the best way to look at it, because you want to treat people the way that you would want to be treated. And as long as you're doing that when you're trying to figure out what's ordinary wear and tear, that's probably the right answer for most people. So next slide, Jim. And now we're kind of a little bit off of this, but this was important, at least to me. There's a lot of deposit law and tenant law that's based off of old common law, which is the law of England and forever back. And so if things happen to a property that's kind of an accident, even if it's an accident of the tenant, the old law is tenant's not responsible. And so if you want them to be responsible, your lease probably needs to cover that. And I bring that up in this situation because it's related to the deposit. If it's something that is not a covered damage, you can't take it from the deposit because they're not liable for it. So you can't charge it because it won't fall as a damage that they're owing you. The realtor leases have had this. I forgot to double check to see if it was still in there. I think the apartment association lease has it. I'm almost certain the apartment association lease has it. But most leases that you see floating around don't, because nobody thinks about this. But it's an important consideration for you, because things happen. Next slide, please. Fun facts about attorneys. We're super special. You do not want us as a tenant because we have different requirements, and most of it relates to confidentiality and our record keeping, because the bar knows that we tend to hold things forever. At least the old guys, and they kept giant paper boxes and they have them stored in the garage and wherever, and they want to make sure that nobody's digging through those files. So you do have to give proper notice to the state bar so someone can come clean that out for you. You can't throw that away. A lot of times, again, particularly the older attorneys would keep originals of wills and all sorts of very important documents, and they were the only sources to find those originals. So if you're going in and destroying these records, you're really messing with people. So if you know that you have an attorney, even in your residential properties, make sure that you're thinking about this and dealing with this appropriately. This is also going to mean computers, hard drives, digital media, because my stuff is all on digital now. So I shred everything once the file is done, and I return all the originals. So if I was a tenant and you're like, man, he's had a really nice computer when he died, I want to keep that. No, you can't do that. So that's just a thought for you. Again, how you handle that is up to you, but the law says you need to notify the state bar and let them come handle it. Next slide, please. Questions?
All right, guys, you can unmute yourself. Okay, I see a hand. All right. Wait, where'd you go?
Oh, can you hear me?
Yes.
Yeah.
This is Renee Von Good. So I do have a question, and I may have missed this in the beginning, but when you were discussing the trust accounts and making sure that funds in the trust account stay there isolated because they do belong to the tenants. So the trust account that I have is a savings trust account, and it actually is called escrow because the financial institution was a little concerned and uneasy about calling it trust, but they named it escrow, which is fine. So I have no problem with that. Now, since that is a savings account, there are not checks per se on that account. So what I have done for the few times I've needed to disperse funds to a tenant at the end of the tenancy to refund portions or whole security deposits is only at that time would I take the money, transfer it from that account, put it into the operating account, and then cut the check to the tenant. Is that incorrect, or how should that be done?
Let me say that I think that would be incorrect because of the commingling. So I'll go back and say something that I meant to say originally, and then I'll walk through that. What you call the account kind of doesn't matter. And I know, at least at the local legal aid office, they don't care what you call it as long as you're keeping it separate. So you could have it just in landlord account and not have anything special on it. And that arguably minimally qualifies for a trust account if that's what it is. However, because of liability issues, bankruptcy, or if you get sued and tenant or someone's coming after your assets, you do want to have some indication that it's not meant to be your money to help get that sorted out for a future liability issue, as again, as a protection. But the whole key here is you are not commingling these funds. So if you got it in a savings account, the only way to get that out is to have the bank cut a certified check against those funds and have a memo of who this is for and what this is for, and keep a copy of it. If you take that and put it in your operating account, you commingled those funds to give that back. Now, again, is a question of what the harm is. And so as an attorney, and this is the way I look at it, as an attorney, I cannot do that at all. Like that could cost me my license. If you don't have a license, they can't take a license. So it's a question of what the harm is and how often you're doing it. If you're a property management company and you're doing that, yeah, that's going to cause you a huge issue. If you're a single person and you're doing that and it's happening once every couple of years, there's a risk trade-off there, but no, I don't think that's the proper way to do it. And barring being an attorney and having different rules on me, because I'm an attorney in everything I do, whether I want to be or not. So if I pick up any fiduciary relationships, I have to treat them as if they're an attorney-client. And so I hate that rule, but at the same time, I'm going to do that anyway. So if I was a regular Joe Blow on the street, I'm going to keep everything separate. And that's the way I handle everything. I have operating accounts go in one bank, non-operating accounts go in a different bank, banks from each other, from my own personal stuff, so that I'm not accidentally taking funds and moving them where they don't belong. If that answers your question.
It does. It does. So my takeaway from that would be, and actually those are two different financial institutions, to ensure that the funds stay isolated it's probably best to have a bank check cut directly from that escrow account.
Yes, ma'am.
Okay, got it.
All right, Carrie, go now.
Can you hear me?
Yes.
Okay, I just wanted to suggest to Renee, she might check with her bank. I know that years ago when I only had a couple rental properties that I myself owned and I had to keep them in a separate account, or the trust monies in a separate account from the trust account for rent-a-home, there was a special savings account that had checks, and if you only wrote like 3 checks a month or something like that, there was no bank fees, and it still paid interest and all that kind of stuff. So it's possible that her financial institution might have check writing privileges with that savings account, which might save her a step from having to go to the bank and get them to write a check and all that kind of stuff.
Oh, okay. Thank you, Carrie. I appreciate that.
Sure.
Okay, Mike, and you had a question?
Yeah, please. Thank you, Preston. And embarrassingly, we're very new at this, just have a couple of homes, but we have commingled those deposits and security deposits. And I wonder, given that situation, you suggest we do now to remedy that moving forward, not with new folks, but the folks that are in the couple of houses now.
Well, you said commingled, and so I'm going to specify there's 2 levels of commingled. There's commingled inside the proper account, and that's really just a record-keeping ledger issue. And then there's commingling with your your own funds, and the only thing to do is to take it out. You can't really unring the bell, but you can fix it. So you know what your deposit should be for everybody, and go ahead and take a lump sum out of your operating account if that's where you've got it, and put it in your trust escrow account or whatever you end up calling it, based on your needs and the bank's needs that you're working with. Because some banks will let you use trust account, some will not. But lump sum right now, tomorrow, go and move it, and make sure that you got your ledger set up and you go, okay, well, you just put in, let's say, $10,000. I'm very generous. You got a lot of rentals. And so, but there's 10 different people. So now I've got a major account, 10,000, and then each person has their own ledger and they've got $1,000, and go ahead and set that up to fix it today, because while it might not be an issue and you might be okay, it's better to go ahead and fix it now than wait until it's a problem in the future, and you've got more. It's just easier to just go ahead and fix it. I think that's the answer for you.
Yeah, that makes sense. And also notify the tenants that that's what has been done.
You're asking me a question I have a hard time answering, so I think I'll, not that I can't answer, having a hard time answering.
Yeah, do you stir the hornet's nest or not?
Where you're keeping their funds is, particularly if that changes, and if it doesn't change, just a friendly reminder that the funds are still in such and such institution might qualify you if you need.
I got you. Thanks very much.
You're welcome.
Go ahead, Renee.
Okay, so my question is a follow-on to that, because maybe it's not so clear to me. So when you're saying, Preston, to make a separate ledger for each tenant, each property, do you mean to keep a manual accounting of what is in that trust account, or is that something that the financial institution would need to do on my behalf?
No, your financial institution is not going to do that. They're going to send you one lump sum statement. And so it's your job to either manually with software or a bookkeeper separate that out. And so I call them sub accounts. That's the way I think about them. And luckily enough, QuickBooks works with them as sub accounts. So if you go in and you have a higher level trust account, and that matches up exactly with the bank's statement. So it sees everything that came in and out at
Right.
the trust account level. But then you have the sub account for each tenant, each depositor or group of depositors, because some tenants, you got multiple tenants, one deposit. So you're going to have inside that trust account, you're going to have a different individual ledger for that deposit. So again, you've got $10,000 over 10 properties. You're going to have 10 sub accounts, and each one of those accounts is going to have its own notation for, I had $1,000 come in, and then whatever happens to make that go out. And so if you then reconcile, whenever you do your reconciliations, monthly would be a good answer. At least quarterly, but probably monthly is a good answer. I think that's what the realtors have to do. You want to come in and go across my entire account. These are the checks that got cleared. This is the funds that came in. And so when you're matching them up, and again, and this is in QuickBooks, if you're doing this on manual, you're manually going to make it match. You're going to do it twice. But QuickBooks, if you have them in proper sub accounts, you look at the main account and you go, this cleared, this cleared, this cleared, this cleared, both the deposits and the outgoing checks. And then when you go look at the sub account ledgers, it's going to have already cleared them in the accounts. So you'll see which ones are related, because you're going to look at, you want the granularity of not just the money coming in, but whose money came in and whose money left. Did that answer your question?
It does. And we are still only talking about the account for the security deposits, correct?
Correct.
Okay, we're good. I'm good on that because, I mean, I only have a handful of properties, so it's fairly, well, very easy for me to keep up with that. And I do that, you know, every time I get the statement, and I can kind of do my tallies and match it up with what I know where the amount should be for each person. Okay.
Yeah, and if you got just a handful, like 5 or less, I mean, you're doing this on a sheet of notebook paper, and you may have a separate one for each one. It doesn't have to be complicated, but if you're going to have a lot of properties, it's going to be, unfortunately, slightly more complicated, again, depending on how you're going to do it.
Right.
Okay, go, Carrie. You've got your question, Carrie.
Yes. The other thing that I thought it might be good to remind people at this point is you're supposed to be making a copy of their security deposit check or money order, or you know, if you took cash, you are supposed to take a picture of that and save it.
I think that's a good idea. I think that's a realtor rule. I don't know that you really have to, but coming back from a fiduciary standpoint, it's the smart idea. Is that we don't make copies of cash, because that's illegal.
Well, okay, you're right. Good point. Good point. The other thing too is I think a lot of times when people are just starting out, it is wise to have you know, separate security, have the security deposits in a separate account for sure. It's a lot of trouble.
Different color checks, red checks.
Yes, that helps.
All right, Jeff, did you have a question or comment? Okay. Go.
Hey, Jennifer.
Hey.
Mike and Patty.
Hey, Mike.
Yeah. Now, if we got that money sitting in a separate account, and it's basically an interest bearing, and I know we're getting a lot of interest off of this money, but what happens to that interest for us and or the tenant? That's my question.
Can you repeat that? Because I missed that. Hello?
Oh. Mike, go again. You're muted.
It must be my PC.
There you go.
Okay.
You're on now. You're on now.
Okay, the question is, these deposits are into a interest-bearing account. What happens to the interest to this money that's in there?
What's your lease
Does it
say?
go back to the tenant or to stay with us? Thank you.
Yeah, it's what does your lease say? And again, most everything with the contract is going to go back to what's the contract say. That money belongs to the tenant because it's being earned off of their money, and would belong to them unless you say otherwise. So if you do have an interest-bearing account and you did not say that you get to keep the interest because trying to return them 50 cents or account for that is a pain in the butt. You got to do that. So almost every lease I've ever seen does that, or they end up putting in a non-interest bearing account to help avoid that. But yeah, it's the interest belongs to the tenant, and because of the security deposit maximums, you can't keep it and add it.
Okay, guys, we're gonna have Jeff ask the last question or comment. Go ahead, Jeff. Jeff, you're unmuted. All right, Jeff, we're not hearing you. So it's 7:10, guys. This has been very interesting. I've recorded the meeting, and I will get the meeting minutes ready. And now I will turn it back over to Miss Andrea to close.
Right. Jen, how do I get my picture thing back on there?
Oh, sorry, dear. I'm getting there.
Okay, thank you. That's okay. Doesn't matter.
There you go. There you go.
Okay. Am I done?
You have to accept yes.
How do I Okay, very good. All right, Preston, thank you. We appreciate that.
Yes, ma'am, you're welcome.
It was very interesting. We appreciate that. We learned a whole lot, or at least I learned a whole lot. Sure did. And we appreciate everybody joining in. Thank you for coming. Just a reminder, we will not have a meeting next month. Everybody will be on vacation. And if you'll invite me, I'd love to go. Jen and I will both be there, as long as we're going to the beach, right, Jen?
Yeah.
Because we're both beach girls. So just give us a call and we'll hop in the car with you. Be on the lookout for Jen's details on the next coffee chat, which will be next Tuesday, the 16th. And thanks everybody for participating. We will not see you next month, but we will see you in August. We appreciate you coming, and that will end our meeting tonight. We appreciate everybody participating. Thank you. Thank you, Jen, for setting us up. Thank you, Preston.
Thank you all. Preston, thank you.
Thank
Thank you, guys.
you, Jen.
All right. Y'all have a nice evening.
Y'all too. Drive safe.